Hello friends, in the series on income tax cases, today we will discuss a very important case in which the assessment of an assessee was completed under section 143 subsection 3 on the basis of documents found in the search of other assessee. The issue before Honorable ITAT C bench was that if the assessment is to be completed on the basis of some documents which have been found in the search of another assessee, so whether in that case the assessment under section 143 subsection 3 is to be completed, or the assessment is to be completed by following the procedure which is given under explanation 2 to section 148 and more specifically clause III and clause 4 to explanation 2 to section 148. This issue has been taken up by Honorable Delhi ITAT C bench in the case of Ramesh Jalpuri versus Deputy Commissioner of Income Tax, and this case is reported in 186 taxman.com 1169, and the matter has been decided on 20th May 2026. In the present case, the matter relates to the assessment year 22-23. A search was conducted in the case of Alfex Montage Group, and in that search Excel sheet was found from the office of the HR manager of that group. According to that Excel sheet, cash has been paid to the top employees of that group in addition to the salary which has been given by check and which has been shown by those employees. The assessment of the assessee was completed under section 143 subsection 3. During the assessment, various queries were made, and the addition was made in the hands of the assessee for the on-money salary received by the assessee in addition to the salary received by the check or the banking channels. The CIT appeal also upheld the addition under section 143 subsection 3. In addition to the merits of the case, the assessee challenged this assessment on the legal ground also, and the contention of the assessee was that no addition has been made on the basis of the documents found in the possession of the assessee. It was the contention of the assessee that whatever the additions have been made, that additions are based on the Excel sheet which has been found from the office of the HR manager of the searched group. So it was the contention of the assessee that the proper procedure of assessment has not been followed, the due course has not been adopted. The right course was that the clause 3 and 4 of explanation 2 to section 148 should have been followed. Since in the present case that clause 3 and 4 of explanation 2 to section 148 has not been followed, and by passing that procedure, the assessment under section 143 subsection 3 has been done. So the assessment should have been quashed on this ground alone. Friends, why this contention is important? Because in section 143 subsection 3 proceedings, when the assessment is done, no approval of the additional commissioner is required. But if the assessment of the assessee has been taken up under clause 3 and 4 of explanation 2 to section 148, then in that case the assessing officer has to take the approval of the additional commissioner. So there was safeguard for the assessee when the assessment of the assessee is completed under explanation 2 to section 148. So the contention of the assessee was correct, that the prejudice has caused to the assessee, and it is a settled law that when a procedure is not followed or when some task is not done in a particular manner which is prescribed for that manner, for that purpose, then that act is not legally valid. So when the tribunal heard the matter, the tribunal said that in the present case, the assessment done under section 143 subsection 3 is not valid. In the present case, the right course of action was that the assessing officer should have issued the notice under section 148 by taking the due care, and the assessment should have been completed under section 148. Friends, this case is very important because it is the very general practice and it is a very regular practice that the department chooses the sections interchangeably, but this is not allowed. If the assessment is to be done under section 148, it should be done under 148. If it is to be done in 143 subsection 3, then it is to be done in that section. So the assessment was quashed solely on the ground that it was done under section 143 subsection 3 in spite of section 148. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Ramesh Jalpuri versus Deputy Commissioner of Income Tax, and this case is reported in 186taxman.com 1169, and the matter has been decided by Honorable Delhi ITAT C bench on 20th May 2026. Thank you, friends.